Good morning, Mr. Reyes.
Good morning, Your Honor.
Always a pleasure.
Great to see you today. Same here, sir. Look sharp, Judge.
You're Miss Grab?
Yes, good morning.
Good morning, ma'am. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Here's where the story kicks off. A late-night traffic stop in Texas. Notice how quickly this escalates from a simple speeding ticket to a full-blown DWI case. Bloodshot eyes, slurred speech, and a breath test over the legal limit. Do you think admitting to just 2 glasses of wine ever convinces a judge?
You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 9th, 2025, at approximately 1:08 a.m., an officer observed a vehicle on the 5,000 block of Westlow Road, Harris County, Texas, speeding going 58 miles per hour in a 40-mile-per-hour zone. This was confirmed by Dr. Rear. The officer followed the vehicle and observed the vehicle to fail to maintain a single lane several times. A traffic stop was initiated. The vehicle did not initially stop. The officer initiated sirens, at which point the defendant's vehicle increased in speed and continued to fail to maintain a single lane and failed to signal lane changes to get around another vehicle as the officer was in pursuit. The vehicle finally came to a stop. Officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have red, bloodshot eyes, thick, slurred speech, and the strong odor of an alcoholic beverage upon her breath. The defendant admitted to coming from a wine bar and said she had 2 glasses of wine. As the tests were conducted, 6 out of 6 clues observed on the HGN, 5 out of 8 clues observed on the walk-in turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read, and the defendant consented to a breath test. The results were 0.100 and 0.101.
You said she was going 50 speeding or 40?
58 miles per hour and 40 miles per hour.
Got it. Okay. All right. Ms. Grab, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
You have a lawyer. He will take care of you. Because you do, I will waive your appearance. Just stay in touch with him and he'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. Oh, does she have a license?
Yes.
No prior DWIs?
No prior DWIs.
Okay, we'll have you sign a reset, Victoria. You're not allowed to drive unless you have valid liability insurance as well. If you don't have car insurance, do not drive. That is a condition of your bond as well. Do you understand?
Yes, sir.
Okay, I'll have you sign a reset, Victoria. You'll get with Fleischer of your bond conditions and you're free to go.
Thank you.
Take care.
John C. Joseph, it's my understanding that you want to talk to him and see why he didn't appear in court on his last court date.
So this is basically an arraignment.
Yes, sir. I understand that we were going to do it as an arraignment.
He's been AWOL. It's now 400 days, 350 days old. Mr. Joseph, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're charged with unlawful carrying of a weapon. Your cases are now 352 days old. It's time to decide what we're going to do. Do you have offers on these cases?
No, sir. We're still waiting for the,
This judge isn't playing around. By ordering an ankle monitor, the court is basically saying, we don't trust you on your word. We're tracking your every move. Remember, flight risk is one of the fastest ways to lose your freedom before trial. Would you consider this fair or overreach?
security video.
We do have an offer, but yes, we are waiting on the security
I
video.
need you to get on it
Absolutely.
like yesterday.
Yes.
I'm ready to set this case for trial. Way too much trauma, and I'm not gonna just.
Yes.
Mr. Joseph, I'm now going to put an ankle monitor so I know where you are at all times. If I find that you have one on now, you take off on me again, I'm gonna make your bonds extremely high. Do you understand? I will
Yes,
give
sir.
you a big flight risk and the bonds will go very high. At some point, someone's gonna stop ponying up all this money. You're just giving free money to bonding companies every time you take off, man. That's all you do. On your burglary case, you're not to have any contact with the complaining witness in these cases. You're not to be in possession of weapons.
Did you say you already have something going on?
Yeah.
Is it from Harris County?
I turned myself in the other day and they ain't doing nothing better.
Don't say anything. I don't want you to say something. Perhaps the magistrate put it on.
I don't see any magistrate conditions, but
He's got 2 cases. Look at the other one, please.
yeah, here then we're supervising an ankle monitor report. We had one on him back in April of last year, but we haven't been supervising it since June due to the warrant.
All right, I want to go back to the original bond conditions that had a curfew with the monitor on now. No alcohol, no dope. What do you do with yourself these days, Mr. Johnson? Mr. Joseph?
I just started looking for a job. No, sir. I just started looking for one, filling the application.
I'm going to bring you back in 2 weeks. I want to see what you have done to get a job. Did you graduate from high school?
No, sir.
That's what we're going to also work on as well. I want to see what you've done to start working on your GED as well. I'm giving you 2 weeks. If you've not done anything, it's not going to go well for you. Do you understand?
Yes, sir.
Okay. All right, Mr. D, we'll give you a couple weeks, but I want him back in 2 weeks here to see what we've done to either get a job or get his GED.
Yes, sir.
Okay, if nothing, then it can go well.
Yes, sir.
All right. Hi, Vic. What's up? What's new, man? Good to see you.
Good to see you.
Happy Friday.
Happy Friday. So.
You mean
I'm gonna do a PSI on it rather than fully upstairs, so it's made my Friday a lot better.
scary though?
It is.
No, let me tell you, I did a PSI once where I was basically going to get probation
Yeah.
and then got smacked with 25.
And
And
it is enhancement. I'm on. And it's working and it's got a lot of support. And it's a really silly case. It's a silly case. It's evading arrest, but it's,
I trust you.
yeah.
You know, you're the best, but PSI, it's just,
There's always risk there, but the state was at 15, so.
yeah.
Melgar, Daniel Melgar, this is my fault, Judge, PTI packet, PTI was yesterday
Okay.
to Abigail and.
Well, not to Judge Geis, right?
Yes.
Okay.
I think
Everything's submitted?
Everything's submitted, all the discovery is turned over. The point was 6, so it's just a little bit above the, I think he will
Why,
get it.
why? So were you denied?
We were told to submit a mitigation packet, yeah.
Okay, so it wasn't a denial and then you appealed,
Correct, correct.
right? They just submitted a mitigation
We
package.
submitted a mitigation
Got
packet.
it. All right, we'll give you a week.
Sounds good, Judge.
Hopefully we can have a decision within a week.
I hope
If no
so.
decision is made, I will waive the appearance. We'll give them a little bit more time.
Okay,
If it's approved, your guy's got to be here so we can send it for a TRAS.
perfect.
Okay?
Sounds good.
Yes.
And then we'll just come back. Hopefully they got it within a week to make the decision or not.
Sir,
Yeah.
it's good.
Okay.
Judge, thank you. Nice to meet you.
Good luck, Vic.
Thank you, sir.
Are you on probation or parole at this time?
Oh,
You were on parole in 22. Is that over now?
yeah.
Okay. So I don't show any holds on you now.
Which one, I mean, is it no hold?
I don't see any. Do you guys? You guys? Yeah, we don't see any holds. But if you continue with what this has happened and this keeps happening, the sentences just get longer, longer, and longer. All of it self-control, Mr. Kaufman. You're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 7 days that you've done. You need to understand that this is going to go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? So Lori, the trespass is being dismissed.
Are y'all dismissing the trespass?
Believe so, yes, Your Honor.
There is a trespass, right?
Here's a trespass. Was there plea paperwork for the trespass?
So they're going to dismiss the other case that you got. But like I said, you're still facing a minimum of 90 days in the future. So you pick up another case, it's just going to be a long time. Do you understand?
So that time served.
Yeah.
Yes.
Yeah.
Oh,
But if you want something, if you need something, we have services for you. If you need a place to sleep, you need food to eat, we got you. All you got to do is ask. But this, you're giving up the right to a trial, right to compel witnesses to testify on your behalf. confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal, Mr. Kaufman. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. I'll send you to it. Good luck, sir. Thanks, Lord.
Judge, can I start with Alator Aristelsi for bond violation? She tested positive on 3/4. On March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to give.
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you set on that, Judge?
$5,001.
5,001. And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, it's the second. The first one was for the same thing.
Take your time, no rush. Deputy, you going? I need your help. No. Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you.
What would you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge?
Thank you. Yeah, 5,002.
5,000?
Yeah.
All right, Judge, and I have one more, and it's Gomez.
Okay. Jorge Gomez, come up.
So, Judge, he did take a drug test today because he had failed to report for a drug test on February 21st, and he tested positive for marijuana.
You see how many people we've taken into custody? I ordered you not to use, and you're now testing positive. If I find that you ever test positive again, I will put you in jail. Do you understand? When I say don't use, I absolutely mean it. You will get tested in 50 days. If I find that you continue to use, into jail you will go. Do you understand?
Yes, Your Honor.
Yes. Absolutely no tolerance here for it. And the next time you miss an appointment, likewise, you will go to jail.
Yes, Your Honor.
Thank you, Judge. In 50 days, Judge?
Yeah, reset 50 days must appear.
Okay, thank you, Judge. Thank you, Judge.
All right, so Mr. McGee, you've worked out an incredible, not you, your lawyer has worked out an incredible deal. You're charged with five, it's 5 open cases, right? Shh. You're charged with evading arrest, failure to identify oneself, evading arrest, theft, burglary of a motor vehicle, and I think that's it, right? As part of the agreement, you're going to plead guilty to the burglary of a motor vehicle and the evading arrest. You need to understand that both of these cases are enhanceable cases, meaning if you pick up another one of these cases, it's very possible they charge you with a felony offense. Now, on the burglary case, it may be 2 or 3. I think it's a third, it's a felony. But on the evading case, you pick up a second one, you're looking at a felony charge, years instead of days. You understand? So I don't know who you're hanging out with. I don't know what you got going on in your life, but you got to surround yourself with better people, because you start the wrong people, they're going to bring you down. Don't become another statistic. We have enough Black and brown people in custody now. Don't become a statistic. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty to these cases. You can't do anything else. It goes on your record. It'll be there forever. How do you plead to both cases guilty? Mr. McGee, if you need anything, just come back, talk to me. I'll get you whatever you need. If you want a place to stay, food, cell phone, tablet, we can work just about anything to get you what you need. It's never a problem.
Yes, sir.
But would you get out there, you get on the street, you got to be careful, man. You get one life. You don't get another one. There's no redos. Good luck, man. It's 30 days. I'm sorry, 30 days in jail, credit for the 29 and 31.
Okay.
It's Tyron, whatever you'd like.
So we can, maybe we
I don't know
can.
about a bond is because it's kind of.
Yeah, no,
It's a free time waiver.
we don't.
Oh, got it.
And maybe we can review PC. I think we're in agreement with the trespass. There was no trespass for the.
I'm always happy to hear PC. Let's do it.
Yeah.
Day, you want to do it or no?
Let's do it.
Okay.
All right.
What's the contract number?
255-4294.
It's on document.
Oh, it is?
Yeah.
Sorry. Okay. On March 4th, 2025, at approximately 10:30 a.m., officers were conducting an investigation for an evading case at Oyo Hotel. The officer made contact with the manager of the hotel, who showed surveillance video that showed a male who had been given several trespass warnings and stated he refused to leave and comes back all the time. The suspect was a black male with a jean jacket and dreads. There is also a posted no trespassing affidavit on the front of the hotel. The officer spotted the male and attempted to make contact with him. The officer approached the defendant and the defendant began walking away, and the officer advised him to stop. The officer placed his hand on the defendant's arm and the defendant began running down the stairs carrying his bicycle. While running, the defendant used his bicycle as a barrier and shoved it towards the officer, hitting his left knee. The defendant continued to run around the motel, and he grabbed his bicycle, which he left on the left side of the building, and the officer was able to take the defendant into custody after a taser was used. The defendant was identified by his Georgia ID card. The defendant has an open probation violation warrant out of Louisiana for a weapon charge.
So he's at a hotel.
Yes,
Was he, you're saying he's not allowed to be there.
correct.
Are you saying he was?
There's no trespass warrant on file with his name on it. I believe there's a homeless encampment near this hotel, off Highway 6. And so a lot of the homeless people go back and forth. Mr. McGee is homeless. I don't know. It's not clear whether Mr. McGee is the person that they're referring to. I know he's a black male with dreads, but he's never received a trespass affidavit. And there's no information of that.
You said that there was one.
It says in the DIMS that the complainant pointed out the defendant on surveillance video and said, I have told him several times, I've given him several trespass warnings and he refuses to leave and he comes back all the time. And then also it
Maybe
is
they were
stated in the
verbal.
DIMS that there's a trespass affidavit posted on the front of the hotel.
Okay, but that doesn't mean anything. That just means like no trespassing.
And usually with
It's
the
like,
trespass affidavits, he was there visiting someone that stays there. So in all of the loitering with convenience stores and things of that nature, that applies to people that are there without any kind of, if you're not buying anything, visiting anyone. So he was visiting one of the people that was staying there. That's why he had his bicycle. The police, I basically just grabbed him and he was coming down the stairs. So I don't think we have a valid trespassing case because there's no affidavit with his name on it. And if he was there legally visiting someone at the hotel.
is a verbal trespass warning sufficient?
I would disagree, Your Honor, especially because this is, and I guess we would need to see what their trespass affidavit says, because usually the ones at the convenience stores, I've dealt with this a lot. It excludes people that are there legally.
I mean, I get that the penal code doesn't say that it has to be in writing. You know, I mean, it could say, hey, I don't want you here. Don't come here anymore. So,
But then if we take that blankly, that there's a trespass affidavit, then that means.
but then anybody could say,
That's correct.
right, I get it.
wouldn't be
I
able
get
to
it.
Go in and visit my aunt, and she was staying at that hotel, so it can't be that restricted. If he was there with his bicycle, he wasn't just out in the front visiting someone, he was up inside of the hotel with his bicycle coming down, he was there visiting someone. So I don't think that there's any information or evidence that says that.
So the state would concede that a general trespass affidavit would not be enough. So it would be due to the verbal trespass warnings that were given to him several times by the manager and him refusing to leave the location.
So where do we go from here? Like, how are we gonna?
My goal is, Judge, or my hope is that the state, in looking at this and knowing that he has a case out of New Orleans, which he's on parole on, I'm hoping that they'll resolve these issues. I have spoken with his parole officer, and he, bond or not, he is going to have to sit in jail another 14 days to be extradited. But because he's on parole, I cannot plead to anything because I want him to get to New Orleans and have the ability to potentially get terminated.
They're coming, obviously, right?
They are,
But it's Louisiana, so they should be here.
it'll be pretty fast.
I mean,
The larger part of it's not Louisiana jail, it's not Burgess and Harris jail, this is a parole violation. I think what council is saying is that for whatever they contend for the parole violation, they're gonna have it before the board. Well, obviously, if he takes a conviction, that's gonna affect his eligibility versus a dismissal.
But there was already a warrant regardless.
Right.
Something happened regardless of perhaps he absconded or.
Because he had been here homeless off the grid, so because he had no residence and things like that. And so that's why. But for conviction here.
Right. The only problem, Ms. Sparks, is that the 14 days or any time it's told.
As long as this is going on.
Because he's not made, you know.
Yeah,
I think one of them can bond too.
I'm showing both their,
yeah, no,
he's not made bond on
we
either.
were
of them.
told it made no sense to me.
If I may, last Friday, we revoked the bond on the local cases to keep Louisiana from coming to get him.
Oh, that's this one?
I don't remember
Yes.
that. I didn't remember that. I thought it was someone else that we.
Yeah.
Okay, so,
So that way then you wouldn't have to go back and forth and deal with the same.
right, you're right, you're right. No, she's right, because the problem is that if they come and get him, he goes over there, then a hold gets placed on the exact same situation. So
I trust Blaze, and his staff.
guys,
I'll stand down.
whatever you want to do, if you want to set it maybe just a couple days to look further to see if there is anything, if you could probably perhaps somehow get that he's actually visiting someone.
Yes, Your Honor.
No,
Okay, yes, Your Honor, I'll stand down.
Yeah.
Thank you.
you know, Mr. Flores, I really don't know what it's going to take to get your attention that we're not going to stand for anyone endangering our public. Really. I mean, you've had in the last 3 years, 3 very serious cases, and now you're picking up a DWI. All of them are dangerous cases. What's it going to take? A 25-year sentence? Is that what it's going to take to get you to realize, you know, all the stuff here is things that if you just think, they don't have to happen. All the time, all the money, all the just that you spend coming here can all be avoided by not using. You know what I mean? That's all it takes. From now on, what we're doing today, you're now facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? There are more proverbial slaps on the wrist. What you're pleading to now is a DWI. This DWI will go on your record. It will be there for the rest of your life. You can never take it off. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences.
This is raw frustration from the bench. Judges see repeat DW is not as accidents but as loaded weapons on the road. That Uber comparison? It's more than sarcasm, it's a warning. So, let me ask you, should DWI sentencing be harsher after the second strike, or is rehab the better answer?
Consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this case, like I said, it'll go on your record. You can never take it off. Do you understand?
Yes, Your Honor.
You know, the other thing is this, is that your lawyer is asking to waive all the fines and fees. If you ever pick up another DWI, it is a $6,000 surcharge that you will be required to pay. And if you don't pay it, you sit 1 day for every $100 you owe. If you want to get lit, 52 beers, 32 shots of tequila, take a freaking Uber. $40 wherever you want to go in this damn city. Don't kill anyone. How do you plead to the DWI? Guilty or not guilty?
Guilty.
I'm going to find you guilty and I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. Don't get into a car. Driving on a suspended license case is just like a DWI. You pick one up, you're going to be right back in here, and it's just not going to go well for you.
Yes, Your Honor.
You understand?
Yes.
All right, good luck.
Thank you, Judge.
I have Mr. Escamilla and Ms. Victoria says we need to approach you on the reset because you sent him for a drug test, Judge.
Use. It is a condition of your bond. I will give you up to 50 days, and I'm going to test you again. If I find that you continue to use, I will put you in jail.
Yes, sir.
No more PR bonds for you.
Yes, sir.
You take off on me again, it's really not going to go well for you. Do you understand?
Yes, sir.
Okay, I put a GPS monitor on him and I've given him a curfew because he's taken off on us many, many times. His case is 1,000 days old. So I'll give you a reset, but I think that we were waiting on, is discovery complete on the assault case?
It says the only outstanding thing is photos from the complainant.
Okay, if you can please
Yes.
get that.
And Judge, just for the record, I was just appointed today. Okay.
No, I'll give you time.
Thank you. Thank
Sure. But I'm gonna test you like crazy.
Yes,
Just
sir.
get ready.
I'm working. Yes.
It's on your ball.
Yes, sir. Understand.
It's your responsibility to stay in touch with her too. If she tells me she can't get a hold of you because you're ducking and dodging, likewise.
Yes, sir.
Jail you will go.
Understand.
All right?
And
Okay, Ms. Tichy.
Yes, Judge, we've had a long talk this morning
Good.
and he was really good about communicating earlier.
and
Okay.
for my
Yes.
curfew, I work a night shift. I work 5 p.m. to 5 a.m. So
Judge, can it change to allow him to work?
I want proof. Show me proof. I'm not gonna take your word
All
for it.
right, but she'll send it to me and by Monday I'll bring it in and we'll adjust. Does he need to be here if you're gonna adjust the curfew or can I just come show you?
I want, bring me legitimate proof and we can
And then we'll
talk.
talk.
And then, but remember, the GPS monitor tells me exactly where you go
yes, sir.
at all times. So if you deviate,
Just worry about yes, sir.
all right, okay.
I'll get the proof, Judge. Thank you so much.
Yes, ma'am.
All right, have a seat real quick.
Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 p.m., an officer observed a vehicle parked in a handicapped parking space with no displayed license plate or placard and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted and 4 bags were located under the driver's seat, 0.154 ounces.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm going to appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens. Okay? All right, man. Good luck.